Embarking on the journey of estate planning is a profound step towards securing your family's future and preserving the legacy you've worked hard to build. In the vibrant heart of San Antonio, Texas, where family and heritage are deeply honored, establishing a well-drafted estate plan is more than a legal endeavor. It's a way to ensure that your wishes are fulfilled and your loved ones are protected. At Family Matters Law Firm PLLC, our San Antonio estate planning lawyers are well versed in creating bespoke estate plans that resonate with the unique needs and aspirations of each individual and family. Experienced attorneys from Family Matters Law Firm PLLC discuss estate planning in San Antonio. Estate planning is a critical step in managing your assets and protecting your loved ones. The importance of estate planning for asset protection. Asset protection is at the heart of estate planning. It is about safeguarding your wealth and ensuring that your assets are distributed according to your wishes. In San Antonio, a well-structured estate plan can help you minimize the risk of legal disputes among beneficiaries, protect your heirs from creditors' claims, ensure privacy by avoiding the public probate process where possible, control the management of assets in the event of incapacity, establish clear directives for the distribution of assets. State laws governing estate planning in Texas. Texas law has specific statutes that govern estate planning. These laws dictate how wills, trusts, and other estate planning documents must be created and executed. Key points under Texas law include: wills must be written, signed, and witnessed to be considered valid. Texas allows for independent administration of estates, which simplifies the probate process. Community property laws in Texas mean that property acquired during marriage is owned jointly by both spouses. The state has no inheritance or estate tax, although federal estate tax may still apply to larger estates. Navigating the probate process in Bexar County. Probate is the legal process by which a deceased person's will is validated, and their estate is settled. In Bexar County, the probate process involves filing the will and an application for probate in the Bexar County probate courts, notifying potential heirs and creditors about the probate proceeding, inventorying and appraising the estate's assets, paying valid debts and taxes owed by the estate, distributing the remaining assets to the rightful heirs. Tailored estate planning with Family Matters Law Firm PLLC. In San Antonio, Texas, where estate planning laws shape the future of your assets and legacy, the legal assistance provided by Family Matters Law Firm PLLC is indispensable. Our skilled estate planning lawyers are dedicated to delivering personalized and strategic planning services that comply with Texas law, ensuring your estate is managed and protected according to your specific wishes. Creating your will in San Antonio. A will is a personal declaration of your intentions for the distribution of your property and care for your loved ones after your death. Our estate planning services can help in creating a will that is not only a reflection of your wishes but also complies fully with Texas law. Wills, drafting and execution. The creation of a will is a fundamental aspect of estate planning, and in Texas, it is paramount that this document adheres to specific legal standards to be deemed valid. The attorneys at Family Matters Law Firm PLLC offer quality services that include drafting a will, executor and guardian selection, compliance with Texas law, will updates. Writing a will can seem daunting, but with the right guidance, it can be a straightforward process. In Texas, certain legal criteria must be met for a will to be valid. The person creating the will, testator, must be at least 18 years old, married, or a member of the armed forces. The testator must be of sound mind at the time the will is drafted. The will must be in writing. While handwritten, holographic wills can be valid, typed wills are generally more robust and less prone to challenges. The will must be signed by the testator or by someone else at the testator's direction and in their presence. The will must be witnessed by at least 2 credible witnesses over the age of 14 who are not beneficiaries of the will. Choosing executors and guardians. Selecting an executor, the person responsible for carrying out the terms of your will, is a critical decision. Updating your will, when and why. Life is not static, and changes in circumstances can necessitate updates to your will. In Texas, significant life events such as marriage, divorce, the birth of a child, or the acquisition of substantial assets can all impact the relevance and effectiveness of your will. We recommend regular reviews of your will with an estate planning attorney to ensure it remains accurate and legally valid. Other reasons to update your will may include changes in your wishes regarding beneficiaries or the distribution of your assets, changes in the law that might affect your estate plan, the death or incapacity of a named executor or guardian, trust formation and administration. In San Antonio, forming a trust can be a strategic part of estate planning that offers flexibility, privacy, and potential tax benefits. Trusts can be used to manage your assets during your lifetime and distribute them after your death, often without the need for probate. Types of trusts in San Antonio. Trusts are a cornerstone of strategic estate planning, offering flexible solutions for asset management and future planning. Living trusts. Living trusts are a popular estate planning tool that allows for the effective management of your assets during your lifetime. Special needs trusts. If you have a loved one with special needs, a special needs trust is an essential component of your estate plan. Irrevocable trusts. Irrevocable trusts are another form of trust that can play a pivotal role in estate planning. Trust tailoring. At Family Matters law firm PLLC, we understand that each individual situation is unique. The role of trust administration. Trust administration involves managing and distributing the trust's assets according to its terms. In Texas, this process is governed by the Texas Trust Code, which outlines the responsibilities and duties of a trustee. These duties include acting in the best interests of the beneficiaries, managing trust assets prudently and efficiently, keeping detailed records and providing regular accounting to beneficiaries, communicating with beneficiaries about trust matters, funding your trust, best practices. Funding your trust is a crucial step in the trust formation process. Without proper funding, transferring assets into the trust's name, the trust document alone offers little value. Best practices for funding a trust in Texas include transferring real estate by executing a deed that names the trust as the owner, changing titles and registrations for assets like bank accounts, stocks, and vehicles to the trust's name, designating the trust as a beneficiary for life insurance policies and retirement accounts. Medicaid asset protection. Medicaid asset protection is a critical strategy for individuals who are planning for long-term care and wish to preserve their assets for future generations. As medical expenses and the cost of long-term care continue to rise, it becomes increasingly important to understand how to structure your assets to maintain Medicaid eligibility. Our skilled attorneys can assist you with Medicaid trusts, asset transfers, spousal protections, exempt asset planning, crisis planning, advanced estate planning strategies. For individuals with substantial assets, complex family situations, or specific legacy goals, advanced estate planning can provide tailored solutions that go beyond basic wills and trusts. Tax minimization techniques in estate planning. Effective estate planning often includes strategies to minimize the impact of taxes on an estate. Texas, while having no state estate or inheritance tax, still requires careful planning for federal estate taxes and the potential for capital gains taxes affecting beneficiaries. Our attorneys employ various techniques, such as utilizing lifetime gift exclusions and annual gift tax exclusions to transfer wealth during your lifetime, creating irrevocable life insurance trusts to exclude life insurance proceeds from your taxable estate, structuring trusts to take advantage of the marital deduction and bypass provisions, exploring opportunities for valuation discounts through certain types of asset transfers. Business succession planning. Succession planning is essential for family-owned businesses to ensure smooth transitions without disrupting operations. Texas business owners should consider developing a plan, training successors, estate equalization, charitable giving and philanthropy in estate plans. Incorporating charitable giving into your estate plan can fulfill philanthropic goals while providing tax benefits. Our estate planning attorneys can assist with establishing charitable trusts, such as charitable remainder trusts, CRTs, or charitable lead trusts, CLTs, to provide for charities while also benefiting your heirs. Setting up private foundations for long-term philanthropic endeavors with potential tax advantages. Advising on the use of donor-advised funds as a flexible and tax-efficient method of charitable giving. Family limited partnerships and LLCs. Family limited partnerships, FLPs, and family limited liability companies, LLCs, are entities used for both asset protection and estate planning. Call 210-997-2914 to schedule a consultation with one of our San Antonio estate planning attorneys and take a step towards a well-prepared future for you and your loved ones.